Hi, my name is Marc Rosenberg. I'm an attorney at Beresford Booth. I've been a litigator for about 25 years now, but this is my first webcast, so please don't judge me too harshly. I'm going to give you a quick caveat that this is not legal advice. If you have any issue, you would need to set up an appointment with an attorney. But what we are going to do today is talk about dispositive motions, which is one of my favorite things to do during litigation. And when appropriate or done right, they can lead to dismissal of a case pretty early on without having to go to trial. So we're going to talk about them now. The presentation today is called What are Dispositive Motions and How Do We Use Them to End a Case Before Trial? And so let's get started. Let's start with some introductory concepts. First of all, you're going to hear about the rules. Now, the rules are Washington Rules of Civil Procedure, the rules that lawyers are supposed to follow in civil cases. There's a different set of criminal rules. These are civil rules. If you see CR, it generally means a civil rule. And it lays out everything a lawyer is supposed to do during litigation, pretty much. Everything from how to file, how to serve, a complaint, what you do when you get a complaint, how to answer it, how to draft it, everything through the course of the case. So we're going to talk about civil rules, or CR, and each of the dispositive motions has its own number for civil rules. Now, a motion is where you ask the court to do something. So if you want to get the case dismissed, you make a motion to get the case dismissed. And when you make a motion that is dispositive, it's dispositive when the answer determines the outcome of a case or a claim. Now, every case is made up of two things. It's got the law on the one side and facts on the other. And usually a jury will decide the facts and a judge will decide the law. But when the facts are agreed, or at least not disputed, the judge can decide the whole case as a matter of law. And when the judge decides the case or parts of the case without a jury, that is generally as a result of a dispositive motion. So we're going to start off by talking about motions under Rule 12b-6. So again, that's a civil rule, and it's rule number 12, and it's part of the discussion about how do you respond to a complaint when you get it. And one thing you can do is answer. Another thing you can do is file a motion. And these 12b-6 motions are brought at the start of a case prior to filing an answer. And so one thing you're going to want to do when you get a complaint, if you get one, if you're not the one serving it, is determine when service occurs and make sure you have time to prepare a motion. Generally, you only have 20 days to answer a complaint. And so by the time you get it, it's not a lot of time. If you think it's going to take more time to basically answer and file, then you can also still bring a motion to dismiss after filing. It's just a different rule. It's Rule 12C. But by that time, you've already filed an answer. You've provided basically a little bit of a path on where you intend to go in the litigation without getting the case dismissed. Now, there's some significant differences in regard to state and federal rules. We're generally only going to be working with the federal rules today. I mean, state rules, excuse me. I may mention the federal rules, but generally we're talking about the state rules. And when you make a 12b-6 motion, basically all the court is looking at is the complaint. The court doesn't generally look beyond the complaint, but there are exceptions, and we'll discuss that momentarily. You basically want to consider the risks, because sometimes if you're asking the court early on to decide a point of law, you don't want the court to come out against you too early before you've had a chance to present sufficient evidence. But in some things, for example, where there's statute of limitations that's clear from the face of the complaint, you can bring a 12C motion without too much risk of that happening. And so when we're talking about a 12B6, as I said, there are certain standards that are applied in state court. Now, Washington has rejected the federal standard, which is plausibility. A complaint has to be plausible in order to withstand a motion to dismiss or a 12B6 motion. And so it's a very significant difference between true notice pleading in state and federal court. And notice pleading basically is the complaint has to provide a short, plain statement about what your case is about. Has to be much more detailed in federal court, can be very simple in state court. And in Washington, if the judge can think of any set of facts on which the motion fails, then it will be denied. So basically, the court can sit there and make hypotheticals and presumptions in a 12B6 motion. And if there's anything that, if there's any hypothetical set of facts by which the motion fails, then the motion fails. We're going to talk about judicial notice next. Now, if you remember, I said basically the court will only look at the complaint when deciding a 12B6 motion. Basically, the court accepts all the facts as true. However, one exception to that is something called judicial notice. The court can consider things such as documents attached to a complaint without changing it from a 12B6 motion to summary judgment. And we're going to talk about summary judgment momentarily. But this early in the case, you don't want your 12B6 motion converted into a summary judgment motion because generally you will not have submitted sufficient facts in order to withstand a defense to that motion. But in any case, the court can take judicial notice of documents. For example, if there's orders that have been entered in this court or other courts, or if there's a deed to a property that's recorded with the county, or things that basically you can't have too much of a dispute over, the court can still consider these on a 12B6 motion without changing it into a summary judgment motion. Now, if the court does consider things outside of the complaint that don't fall into these categories, generally they can convert it into a summary judgment motion right up at the beginning of the case. And generally, for a summary judgment motion under CR 56, you have a different standard. And the standard for the CR 56 is generally you present evidence to the court or point out the lack of evidence in the other side's case. You can submit declarations, you can submit documents, and generally summary judgment is appropriate if there is no genuine issue of material fact, and you can have some issues without defeating a summary judgment motion, but the issues have to be genuine and the facts have to be material. And so basically, if there's no genuine issue of material fact and a party is entitled to dismissal as a matter of law, that's the standard for a summary judgment. And for either summary judgment or a 12B6 motion to dismiss, you're going to want to start off looking at the complaint. So scan the complaint and review it. You can take notes. You can start a memo. I mean, your lawyer is probably going to be doing that. Or if you're a lawyer out there watching, these are just tips that you might consider. Look at the complaint. Are there dates in it? Will those dates support a statute of limitations argument? Was there a prior lawsuit? There's something called estoppel. So if there's a lawsuit and it's the same people and it's the same general topic, and there's a couple of other elements that are the same, those orders or decisions in the prior case might decide an issue in your case or might preclude the case. Um, where are the parties located? Where did the events occur? Where is the property at issue? You might be able to challenge a case on jurisdiction or venue. So if all of the defendants live, in a different state, well, maybe that state's where the case should be. Or if a property is located in King County, let's say, and you live in Snohomish County, well, perhaps the lawsuit is in an incorrect venue or incorrect jurisdiction. This is if there's a municipal entity or immunity or things like that, that may or may not happen. But it's not that unusual to have a bankruptcy at issue. One party or more than one party might have had a bankruptcy, and there's some pretty powerful things about bankruptcy. They have something called judicial estoppel, which is a little bit different than the estoppel we were talking about. And what that basically means is somebody in the bankruptcy says, I don't own a property. And then a couple of years later, they sue someone else saying, I own that property. Well, their case is going to be dismissed based on judicial estoppel because they made statements in the bankruptcy that are written down and the court relied on them potentially. And so they may have an effect on a case. Analyze the elements of each claim. And again, the summary judgment, it's much the same as a motion to dismiss, but you're more likely to challenge the elements of a claim. And what is an element of a claim? Well, those are the things that make a claim what it is. So, for example, if you have a negligence claim, that's one of the common types of claims you have in a lawsuit. What are the elements of negligence? Well, you've got a duty, a breach of that duty, injury, and the injury has to be caused by that breach of duty. If you have something like a Consumer Protection Act claim, what are the elements of that? Well, you have an unfair or deceptive act or practice in trade or commerce that affects the public interest. You've got injury, and the injury has to be caused by that unfair or deceptive act or practice. And one thing you do when you do a dispositive motion, like a summary judgment motion, is you attack the elements of a claim. Because if any one element fails, the whole claim can fail. And so you may want to start planning from the outset. Even if you can't bring that 12B6, you might start planning for a summary judgment. And so at the very outset, you may in your mind want to lay out the motion, whatever headers there are, the subheaders, determine the elements of each cause of action. And this framework will help determine what facts you need to support elements or to attack elements. You can start declarations and send out what we call discovery, which are interrogatories or requests for production, where you try to get documents or statements from the opposing party, and you can use those to help you support a motion. And you keep the summary judgment motion current as you go through the case. You determine who you need to depose. And, some people do what's called a discovery deposition. And a deposition, of course, is when you ask the other side or other people questions in front of a court reporter who types down everything. And that testimony can be used in the court. And generally, before that deposition, some people, they do a discovery deposition. They just ask questions and find where they lead, trying to discover what the other person may know. Personally, I generally, with many witnesses, want to have a narrative and documents that I've gathered together. And I put together the narrative that I want the other side to tell. And then I use the documents to get them to tell it. And if they disagree, I'll put a document in front of them and then another and then another. And hopefully then we can support that summary judgment motion and get the case dismissed. You may want to get experts early, again, especially if it's in federal court. Um, well, that's for federal there. Let's go to the next thing here. We're going to talk about pretrial motions and trial motions. I'm going to be very brief on these. There's three trial motions. You've got the pretrial motions under CR 12D, Rule 12D. Basically, you can make these motions before the trial starts. You get right up until the trial and try to get the case dismissed before any witnesses talk at all. Then you've got halftime motions, and this is after the plaintiff finishes. After the plaintiff finishes their case, after they rest, you can go to the judge and say, hey, even if you consider all the evidence that the plaintiff put on, it's not enough to support the claims that they're making, and you should dismiss it now before the defense even has to start. And then the post-trial motions, well, that's the same type of thing, except after everybody's done, then the each of the two sides can go up and say that they think that the case should be either granted or dismissed. And just briefly here again, there's a variety of information here, but there are specific defenses that can be made prior to the trial or through the trial. In a bench trial, the court can grant a motion to dismiss at the close of the plaintiff's case, either as a matter of law or a matter of fact. Dismissal is proper if there's no evidence or reasonable inference therefrom. That would support a verdict for the plaintiff. And you might notice I've thrown in some cases here and there to support what I'm saying on a variety of points. As a practical matter, parties can make halftime motions to dismiss for failure to make out a prima facie case, even in jury trials. And then we have something called a judgment notwithstanding the verdict. And again, this is a post-trial motion, JNOV. It's proper only when the court can find, as a matter of law, that there's neither evidence nor reasonable inferences sufficient to sustain the verdict. The motion for JNOV, again, notwithstanding the verdict, admits the truth of the opponent's evidence and all inferences that can be reasonably drawn, and requires the evidence to be interpreted most strongly against the moving party. And even if you do that and show that they still can't win, the court can still dismiss the case. These are often hurried and difficult after a long trial, and they're a long shot, but sometimes they need to be done. In any case, there's a lot more to learn. You certainly can't learn everything in 10 or 15 minutes, but these dispositive motions can be very useful. I've enjoyed making them throughout my career. They can sometimes end a lawsuit in the first month or two, sometimes several months out. And often, if there's grounds for it and done right, they can end the case long before trial and without all the expense of discovery in the case. In any case, thank you very much for taking the time to sit with me here. And certainly, Beresford Booth would be happy to have you call and check in regard to this type of thing and others. And I welcome you to and invite you to look at our website. And hopefully you will find lots of fine things there. And perhaps one day we can do business together. In any case, you have a great day. Thank you very much. Take care.